Very good morning. I bid to Dr. Hanif. My name is Barga Vilashini Anak Perempuan Alakaswaran with the matrix number of A162822. Today I will be talking about the doctrine of corporate governance and competition law in Malaysia. So what is competition law in Malaysia? The existing competition law in Malaysia is in the form of consumer protection from anti-competitive practices and monopolies and has a somewhat limited scope. The common law doctrine of restraint of trade is codified in Section 28 of Contracts Act 1950, which read as follows. 1. Section 28 provides agreement in restraint of trade are void. 2. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. However, there are few exceptions to this provision. Exception 1. One who sells the goodwill of a business may agree with the buyer to refrain carrying on a similar business within specified local limits so long as the buyer or any person deriving title to the goodwill from him carries on a like business therein, provided that such limits appear to the court reasonable, regard being had to the nature of the business. Exception 2. Partners may, upon or in anticipation of the dissolution of the partnership, agree that some or all of them will not carry on a business similar to that of the partnership within such local limits as are referred to in exceptions 1. Exception 3. Partners may agree that someone or all of them will not carry on any business other than that of the partnership during the continuance of the partnership. Note that this contractual provisions is limited in its operation in certain and limited situations only and is subjected to the exception of reasonableness. So the most direct passage for the introduction of competition law in Malaysia is likely throughout the enactment of legislations by the Parliament. The difficulties, however, be in the form of scope and extent of the competition law to be introduced and the policing and enforcement machinery. Which model of competition law and the proper policing and the enforcement agency created are essential matters undertaken for consideration. The competition law in Malaysia is simply governed by the Competition Act 2010. The Malaysian Competition Act 2010 has come into force since 1st January 2012. However, this act prohibits a anti-competitive agreement, which means agreement involving a horizontal or vertical agreement which has the object or effect of significantly preventing, restricting, or distorting competition in any market for goods or services in Malaysia. And B. Any conduct by enterprises which amount to an abuse of a dominant position in any market for goods or services in Malaysia. What are the roles of the Malaysian courts? Due to the similarity in the laws and legal system in most Commonwealth jurisdictions that inherited the English common law system, Malaysian courts have long used judicial decisions of other Commonwealth countries as a guide or reference when deciding legal issues. Thus, it is not peculiar to have statutory recognition of the applicability of English legal principles, especially in commercial matters. This is stated in Section 3 and 5 of Civil Law Act 1956. Furthermore, Commonwealth countries do have similar legislative provisions. The earlier Federal Court in Director General of Inland Revenue and Kulim Rubber Plantations 1981 had stated that insofar as the decisions of other courts are concerned, we have always treated these judgments as of only persuasive authority, but we have never lightly treated them or refused to follow them, unless we can successfully distinguish them or hold them as per inquirium. Other than for these reasons, we should, as a matter of judicial committee and for the orderly development of law, pay due and proper attention to them. Should an issue relating to competition law arise before a Malaysian court, so will that court consider its application or merely treat it as not part of the lex loci of Malaysia? This situation seems to be possible if certain principle of competition law find itself recognized by the Malaysian court. What are the concerns of competition policy in Malaysia? The fundamental concern of any competition policy is the basic principle of a fair buying price at all transaction levels. This principle has not been crystallized anywhere from the buying side, as the seller expects, if possible to maximize sales and in this case sourced from a fair price. Currently, Malaysia lacks comprehensive fair trade policies and their legal support mechanisms. There are various specialist legislations for telecommunication through the Communications and Multimedia Commissions (CMC) and within the guidelines for the regulations of acquisitions of assets, mergers and takeovers as well as the Malaysian Code. However, what is acceptable percentage of market domination must vary among industrialized and industrializing countries, and in the case of industrializing countries such as Malaysia, several problems arise as to the merger and acquisition policies of needed foreign investments. The result must be that the investor with foreign development investable funds does so without exposing Malaysia to international or national trade. Fair trade laws irrespective of the Malaysian legal situation, while the complementary Malaysian legal situation supports a domestic competitive environment. Consideration of industrial supports by the government of Malaysia has to be a carefully considered set of policies and premises using a set of guidelines, which is 1. Workable and sustainable competition is the basis of the industrialization of Malaysia. Competition is not to be a destructive element of industry, but it must build upon new experiences and promote long-term growth over industry as a whole. 2. Efficiency is not a static goal. Once achieved, it currently means a comfortable existence. Efficiency is a dynamic goal so that efficiency and change are given and normal. 3. The velocity of industrial development is critical, and this will require a combination of competition and cooperation within all industries. 4. Profitability and reinvestment of profits is encouraged. So, what are the issues to be addressed here? First, the known problems that Malaysia faces are similar to other countries that wish to advance into the next and higher levels of international trades. Seminars, conferences, international meetings with trade ministers and other conventions have discussed the varying policies and laws necessary for a country such as Malaysia to overcome local reticence and custom to become truly international in attitude and policy. Domestically and regionally developing countries need to examine the total scene and the advantage and disadvantages of becoming part of the trading world as an equal partner. 3. If there is to be an outsider aiding in these processes, the recommendations are that a culturally aware person or group of people who understands both sides of the problem give the necessary assistance. This is to allow the cultural values to remain while becoming a world trader. For an example, Japan, which has remained its Japanese culture and at the same time has become a major world trader. Other than viewing public policy in the perspective of competition law, a question that needs to be addressed is the corporate governance measures in Malaysia's capital market master plan. This is in light of recent mergers and takeovers of the conglomerates in Malaysia. If a monopoly is to exist or the ignoring of monopolistic practices along the line with competition law, monopolistic capacity to survive may become a disincentive to improve corporate governance practice. Malaysia's current needs. Malaysia needs to look forward to trade legislation changes if it is to advance as a Malaysian world trader instead of being a member of world trading nations. Japan did this and Malaysia can do this as well. To achieve this goal, recognition of the requirements of world trade within the culture of Malaysia. This means that 1. World quality assistance be sought for legislating the required Malaysian trade laws and policies at the same time protecting whatever possible, retaining the Malaysian culture. 2. Establish from these policies, laws and regulations, administrative institutions to provide the enforcement and regulations of internal and external trade matters. 3. The form of advice formed from these new legislated procedures requires an advisor, perhaps resident in Malaysia, to guide Malaysian trade throughout the labyrinth of international trade regulations. And 4. Recognition of self-interest of Malaysia's international business and the reality of their political pressure. Advocates of Malaysian and their other foreign interests put their case in this situation where channels are available. So in conclusion, in spite of trade, Malaysia should not shut its trade doors altogether. Malaysia should take the first step of allowing competition applied among listed entities that include the regulatory listing of foreign competitors. Malaysia may have its listed exchange with more activities and less poor listed entities in its disclosure-based regime and market economy path under its capital market master plan. Competitive pressures want to be more efficient, leaner and meaner. This is the very essence of capitalism. It is wrong to say that only the consumer benefits. If a firm improves itself, re-engineers its production processes, introduces new management techniques and modernizes, all in order to fight the competition, it must reap the reward. Competition benefits the economy as a whole by a process of natural economic selection where only the fittest will survive. That is all from me. Thank you.